of your 3-year-old daughter, and you were sentenced to 7 years hard labor, which was suspended, 5 years supervised probation. So tell me about that one. That's the first one I'm going to ask you about.
Yes, ma'am. That one was basically because of a divorce I was going through, and I was fighting for custody of my child. And even the judge and my lawyer was basically saying, look, if you put this 3-year-old child on the stand and she just started crying, she doesn't have to say a word, the jury's going to find you guilty. That's why I didn't do any prison time, but that was the only way out. And they basically advised me to take a guilty plea. And later on, after I did, he even gave me joint custody of the child.
Custody of the child, not joint custody of my child. I don't know, just one thing that stuck out with that response. Now, Miss Stapleton, the victim's advocate, is going to go through a long list that seemingly doesn't end of crimes that he committed, and he has an excuse for all of them. Now, he's here asking for a commutation of his sentence to shorten his ultimate sentence, make a recommendation to the governor so that he can receive parole eligibility sooner than he already has it. And, well, I don't know. I'll unpack it with the details at the end.
Okay, and we have before us Mr. I don't know how to pronounce your name. So would you introduce yourself? Tell us your name and DOC number.
RAYFEL Matter, 296-486.
All right, Mr. Mata. You are here seeking a commutation of your sentence. You were sentenced in January 2011 in Caddo Parish for first-degree robbery. You received a 25-year sentence without benefit of probation, parole, or suspension of sentence. You're not eligible for good time, but you do have your full term date is October 18, 2034. Is that information correct?
Yes, ma'am.
And let me acknowledge that we have your sister here, Ms. Monica Dixon Raymond. She's here to support. We'd like to hear from you, Mr. Mata. Why do you think we should vote favorably for you today?
Well, I accept the responsibility for what I've done. I've taken a lot of classes to rehabilitate myself, and I walk around the prison as a living example of how to live and survive in prison without a write-up. I've also taken the hospice course at Angola at LSP. I'm a certified hospice volunteer. And today, regardless of your decision, I'm glad you've given me this opportunity where I can apologize to Kay Harper, the bank teller at Regions Bank, and all the employees there. Thank you.
All right. Warden Allen, is there anything you can tell us about Mr. Mata?
Yes, ma'am. I think Mr. Mata's been a model inmate while he's been incarcerated. His disciplinary report is spotless. He has no disciplinary report. He's completed numerous classes, and also I looked back in his record, and while he was incarcerated in Texas, obtained his GED through the Texas Department of Corrections.
All right, thank you, sir. We appreciate that input. Before we move on to our interview, Mr. Mata, we're going to ask your sister, Miss Monica, what she'd like us to know. Go ahead, ma'am. You're on mute still. Can you unmute?
Okay, perfect. Thank you.
Right. Go ahead, ma'am.
Hi, I am Rachel's older sister. It has been quite some time since we have been able to be reunited as a family. I live in the state of New York. During this time, we have experienced a lot of loss, as families do. What my hope would be that Ray could be released and be a part of his grandchildren's lives. He has a son. He lost his son while in prison, and they need their grandfather to be able to show them that life you can experience things in life, but you don't have to live that way. You know, his behavior that brought him here, I believe, has been corrected in the last more than a decade that he's been incarcerated. And my hope is that I'm on oxygen, I'm older, and I'd like to see him as a free man being I would say a productive citizen before I leave this world.
Well, thank you for joining us from New York this morning. We appreciate speaking with us this morning.
Thank you for hearing me.
All right, Mr. Motta, your case has been assigned to Mrs. Stapleton. Would you answer her questions, please?
Yes, ma'am.
Hey, good morning, Mr. Motta. I see that you're here before us asking for a commutation of sentence, and what is listed is that you're a third-class offender, but it's listed the first-degree robbery. But as I look at your criminal history, it extends far back and it's very violent. I do see all your programs. I want to acknowledge that you have done all those programs. But then, so starting in '83, you have an aggravated assault with a firearm. That was Southern University. Some of these things are, you got a suspended sentence or you put under supervision for probation. You didn't serve really jail time for them, but they were your crimes. And then in '84, an attempted simple burglary. And then in '86, illegal possession of stolen things. And then the one I want you to explain to me, in 1988, sexual battery, aggravated oral sexual battery of your 3-year-old daughter. And you were sentenced to 7 years hard labor, which was suspended, 5 years supervised probation. So tell me about that one. That's the first one I want to ask you about.
Yes, ma'am. That one was basically because of a divorce I was going through, and I was fighting custody of my child. And even the judge and my lawyer was basically saying, look, if you put this 3-year-old child on the stand and she just started crying, she doesn't have to say a word, the jury's going to find you guilty. That's why I didn't do any prison time, but that was the only way out. And they basically advised me to take a guilty plea. And later on, after I did, he even gave me joint custody of the child. What judge would have done that if they'd really believed I'd done that? I have joint custody of my kids during that whole process and during that whole time of the probationary period. And then they turned around and gave me a pardon about it.
I wonder about that too, what judge would have done that. Okay, so the next one I've got is, looks like it's in 1999. So 10 years later, it was a domestic abuse 4th degree with intimidation and felony violation of a protected order, which is pretty serious, but some people don't take it serious at all. So explain that one. So we're back to another domestic violence situation.
That was in the state of Oregon. You cannot argue in front of a child. You can't, I mean, the same lady, the child called the police. The police came and told us we had a decision to make. In every state I've lived in, laws are different. And the judge advised me at that time, you need to learn the laws because you've lived all over the United States. So we argued in front of a child. She called me out of my name. I called her outside of hers. The 13-year-old child went upstairs and called the police. The police came and say, look, basically y'all got a decision to make. Which one of y'all going to jail? Well, I went to jail, and in the state of Oregon, they don't have bail bondsmen. I paid my own bond, and the same lady picked me up from the jail, and on our way home, we were stopped by the police officer. I was never served a restraining order while I was in jail. And that's when we found out about it, that the state had put the restraining order on me and didn't notify me when I was in jail at the time. And she picked me up and we were on our way home. They pulled us over and took me back to jail saying I violated a restraining order I never knew anything about.
Yeah, I know some states are take domestic violence pretty serious and automatically you can't have contact with your victim. That's just an automatic thing. And the fact that the 13-year-old child called, we have the law, well, the enhanced penalty, which is child endangerment. But I can tell you this, most children don't call 911 unless they're scared themselves. So it's a good law to have. It's also a good law for the state to bring protective orders because a lot of times women do recant. So I wanted to ask you about that one. And then in 2000, unauthorized entry of an inhabited dwelling, simple criminal damage to property, resisting an officer. What was that about? That was in Baton Rouge.
That was my own house.
How did that happen?
35 in Oswego.
So
Neighbors called the police. They had no idea it was me going into my own house. When
okay,
police got there, yes, ma'am.
all right, got you. So that was accidental.
Yes.
There was nothing. Okay, so in 2000, issuing worthless checks. And I don't know, 3 counts of juvenile court. What was going on with that? Does that make sense to you?
Probably for about child support.
Child support, you didn't pay.
It had to have been, my child support is paid. I mean, it's paid up. And I think when I went to jail a few times, they got behind and they called me in the child support court.
I see. Okay. What about the issuing of worthless checks? Was that not valid?
Ma'am, that was so long ago. I'm not gonna make anything up because I know you have it right there in front of you. I put the past behind me 16 years ago, and I really don't remember that, and I'm not gonna make anything up and say to you that, that's not true. So I really don't remember it. I don't recall it.
Maybe
I was on
something
drug, yeah.
talking about your drug issue, because in 2000, right behind that, 2 months later, you pled guilty to misdemeanor theft and were sentenced to 6 months in jail and was suspended and 2 months on supervised probation. So that, I think, again, that was 24 years ago. So do you think that was all going along with your drug problems, which led to your attempted robbery and where we are today?
Yes, ma'am. I mean, basically everything I've done was either trying to get drugs, any means and ways to use drugs. And all of that changed when I started taking responsibility for my life. And on this last charge I'm on now, I actually turned myself in because I had finally said enough was enough, and I stopped digging deeper holes for myself and changed my life. And as they tell you that.
But I saw that, but you have to remember, like, you apologize to the bank teller, but when something like that happens to a victim, a lot of times they don't recover and they're not able to put a traumatic event behind them, like a person, like you said, you moving forward. A victim may move forward and become a survivor, but they never forget the moment that happens to them. And then they're always fearful from that point on. So from a victim's point of view, you left a traumatized person that day. And I know you acknowledged it, but that's still not the same as walking in that person's shoes. So I just want to bring that out. So I don't have any more questions.
Any more questions? All right, I see no more questions. I think we are prepared to vote. Mrs. Stapleton?
I vote to deny based upon the extensive criminal history. Now, you've denied every single thing that I brought up, but based upon that.
Mr. Tillis?
I'll go to grant commutation, 99 years. They get a
Parole eligibility?
parole eligibility immediately.
Okay, Mr. Prater?
Let's see, let me look at something right quick. I'll vote to grant with parole eligibility in 5 years.
Mr. Freeman?
I agree, because that's my only solved problem is you hadn't served for 14 years of a 25-year sentence. So yeah, I think you need to do more, but I vote to grant CTO with parole eligibility after serving 35 years. 20 years.
All right. Mr. Mott, I want to commend you on your conduct record, and I'm impressed by the things that Gordon Allen has said about you. It is noted in the record that your victim, Ms. Harper, expressed no opinion about today's outcome. So based on that information, my vote also is to make a recommendation for a commutation of sentence after serving 20.
Thank you.
So you've received one vote that was not favorable, but you've received 3 votes to grant recommend a commutation of your sentence. So that is the recommendation we'll do by half. Good luck to you.
Thank you, ma'am.
All right. So
You have a good day.
You too. Thank you, Warden.
Yes,
And
ma'am.
Okay, so ultimately what they're going to do is recommend to the governor to commute his sentence from 25 years, I believe, to serving 20 years. So maybe he'll get to have parole eligibility 5 years earlier than he otherwise would have had. We had again another Tillis blunder where he was going to say, I want to commute to 99 years, which is when he only has a 25-year sentence, wouldn't have been doing him any favors. We're going to have a hearing after this with another Tillis blunder, but enough of that. This hearing was just, it's interesting. I almost forgot that he's there initially for this bank robbery. And really it was a bank robbery when I just looked at the doc. I'm like, okay, let's commute this guy. It wasn't a bad bank robbery. He actually turned himself in immediately afterwards. I mean, you can just look at this. Thank you, Richard, for providing it. This is October 14, 2009. A man arrested for robbing a downtown Shreveport bank apologized to the teller after his arrest, saying his actions were an example of what can happen when a person gets hooked on narcotics. I'd like to apologize to the teller, he said. After surrendering to the Shreveport police Wednesday evening and being taken to jail. To the kids, this is what happened when you get on drugs real bad. Kids don't do drugs. I was high and I was wrong. I turned myself in so I could get the help that I needed. He's accused of robbing a bank in downtown office afternoon. Police said he handed a teller a note demanding money. He never showed a gun. He faced first-degree robbery charges. An undisclosed amount was taken, and he turned himself in. And then when I saw this, I'm like, gosh, I hope he gets granted. But then the victim's advocate, Miss Stapleton, and gosh, I know she is, I won't even say growing on me. She has won me over. She is the new victim advocate. She replaced the irreplaceable Mr. O'Shea, but she is doing as good of a job as I think we could have hoped. And she's tough. She is tough, but she calls it out. And I'm sorry, but you can't. The case against him and his daughter. We've seen enough of these cases to I just don't buy it. I mean, as a father, you don't plead guilty to something, to being accused of doing that to your own daughter. And we've seen over and over and over again where the courts will do ridiculous things like give probation. Okay. And I just don't buy it. I can't put myself in the place where I believe that he's telling the truth. And because of that, I just can't, I can't feel good about it. I just can't. And plus you go down the whole long, endless list of convictions that he has, and he had the same kind of excuse. He had an excuse for everything that he had for what he pled guilty to doing to his daughter. I won't say accused of, what he pled guilty of doing. And the list goes on and on and on, where he has another excuse, pre-thought out. He thought about it. What am I going to say? What's my excuse? And I can't root for someone like that. And I wouldn't recommend to commute. Sometimes people are where they belong, and I have to believe that Miss Stapleton is right in this case. You might make about the judge giving him custody, I wouldn't jump to conclusion that what he said there is true. I think that he's smart enough to know that if they can't prove it, that this would just be part of his story. And one telltale sign is, again, where he said, the judge gave me custody of the child, not my daughter, not I raised her, not she's here in support of me. Where is she? Anyways, that's just my 2 cents. Thank you, Richard, for pulling out this case, doing the research. And we're going to watch one more hearing with my favorite ADA, and I know many of yours as well, Tracy Barbera, talking about favorites. Where was our favorite warden at Dixon Correctional. He's not there. I don't recognize this man, this new warden. That's too bad. I know a lot of us love our he's got the worst poker face. What's his name? I can't remember. But and he's for this kind of hearing, I think he would have been like staring mouth wide open at him as Miss Stapleton was reading off all those charges. That's what he would have been doing. But anyways, let's jump in. And with that, let's go.
And on September 1st of 2022, when he signed this request for clemency consideration, he signed a notarized document, and in his own handwriting, he wrote, "I asked her to have sex with me." You don't ask a woman to have sex with you at gunpoint. You force a woman to have sex with you at gunpoint.
Well, that's just a partial mic drop of my favorite ADA, Tracy Barbera. And we're about to watch the commutation hearing of a man who committed this crime back in 1986 when he abducted an LSU student. This case, well, he's been serving life. He has a life sentence, and he's asking the board to commute his sentence to make a recommendation to the governor so that he can have a chance at parole. I'll unpack it with the review of the appeal at the end.
Mr. Washington, your DOC number, as you stated, is 107015. You're classified as a third felony offender. You were sentenced 1984 for simple burglary. You received a 2-year sentence. You have a July 1984 also theft, 2-year sentence. And then we have, those are in Iberville Parish. And then in East Baton Rouge, you have a February 1988 aggravated kidnapping conviction for which she received a life sentence. Before we get started, I also want to acknowledge that we have a representative from the DA's office, Ms. Barbera, in East Baton Rouge Parish, and she'll be making some comments as well. Before we start our interview process, Mr. Washington, we'd like for you to take a moment and tell us why you believe we ought to vote favorably for you today.
Well, after I've been incarcerated for 38 years, ma'am, my life has changed dramatically. I'm not the same person that I was back then. Took a lot of classes to help change my life, and I realized what I'd done was totally wrong. And I have a lot of family support that supports me and wants to see me get out, and I can't thank them enough. And like I say, I am wrong for what I've done. I shouldn't even be here to be saying this here, because there's no way I can even ever explain to why I did what I did, because it was wrong. I take full responsibility, and if I was to get out, if you was to vote for me, I will do everything I can to help other people not do what I've done, change their lives, not to go down the road that I did.
Thank you, sir. We'd like to hear from the folks who want to speak on your behalf. In that we allow a total of 10 minutes. So we'll split that time up between your 3 speakers. And first, we'd like to hear from your mother, Ms. Shirley.
You can sit right there. They can hear you.
Yes, my name is Shirley Washington. I am the mother of Jackie Lewis Washington. I have 4 children. I'm retired from East Baton Rouge Parish School Board. And I spent the first 28 years with Jackie. And based on those 28 years that I had him at home, he was a model child. Never had any problems, never had a harsh word. I never saw him disrespect any elders, which I trained him like that. I had 3 boys, and they all came up the same way. And I've prayed for 37 years for this day. And I pray that you all see fit and have mercy upon his soul, that he would be able to come home. And I prayed for this, that he would walk through those doors a free man once again while I live. We are Well, I'm 78 years old and his dad is 80. We don't have a lot of time left in this world. And I would like to see him come home to spend these last few years that I have. If that many, I just pray that he would be released. He's always been a good child. I never had any problems with him. Not to another person, another older person, unlike the children that they got in the streets now. They have no respect for their elders. But my children, they came up respecting their elders and respecting any other person. I've never seen them give a harsh word to anybody. And I pray that you will see fit to let him come home these last few years that we have.
Yes, ma'am. Thank you so much for being there today. Before we start our interview, Warden Ambo, is there anything you'd like us to know about Mr. Washington?
Yes, Mr. Washington is a minimum aid trustee. He's assigned to Easy 4 and works as a groundkeeper. He has a total of 52 DB reports. The last report was September 16 of 2004 for 30W. He has victim awareness and victim awareness letter training, 100 hours of substance abuse. 100 hours pre-release, substance abuse and anger management. His tiger is low.
All right. Thank you.
You're welcome.
Mr. Green?
Okay, I was assigned the case, Mr. Washington, so I'm just gonna ask you a few questions. Okay, how long had you been out there waiting when the victim showed up?
Well, it wasn't very long, maybe 30 minutes.
Okay, and how often had you gone to this same spot?
That was my first time.
Did you return to that spot later?
Maybe a week.
Weren't you arrested in the exact same spot that you picked up the girl?
Yes, sir.
Any particular reason you went back to that spot? You're looking for another victim?
No, sir, I wasn't looking for another victim. I was riding. I hadn't stopped anywhere.
You had any drug, alcohol problems when you were younger?
No, sir.
You ever did drugs, alcohol?
No, sir.
I seen you had a juvenile record. What was that about?
I think I had when I was working at a store somewhere, I had a burglary charge. I don't remember the full detail of it, but that's the only thing I can
Yeah, it was a
think of.
simple murder.
Yes, sir.
Okay, and then you had two periods of supervision with adult probation, and both of them were revoked. Is that correct?
Yes, sir.
Were you on supervision when this crime happened?
Yes, sir.
And how long had you been out?
I
Period
think,
that happened.
I think about 3 months.
Where you gonna live at? Where you gonna work?
I'm gonna live with my mom and dad, and I'm gonna work with my brother doing lawn service.
All right, I see you have strong opposition from DA Tracy of Barbara and East Baton Rouge, Tony Clayton in West Baton Rouge, Sheriff Brett Stassi and Major Morris. They're both also are opposed, and the chief is opposed. Why you haven't taken too many classes? You only got 4 classes. Yeah, long time.
Well, I just completed Thinking for a Change 2 weeks ago. So we wouldn't show up in my record, but I just got through completing.
I got it down.
Because the class had got shut down.
I got it. I found it too,
Okay.
Mr. Freeman.
Yeah, I have it in my packet. Thank you, Ward. Why did you not take those sex offender classes? I mean, that's major.
Well, they tell me I didn't need it. I went to classification and to find out every class that I needed, and they told me I didn't need this particular class.
All right.
To answer your question, why I haven't taken a lot of the other classes, I came down with cancer. And I had been doing a lot of cancer treatment. So I wasn't in the prison to actually do the classes.
And, sorry to hear that. How's the cancer? It's in remission now?
Well, I'm still waiting on the results from the second time I had it.
All right, I have no further questions.
Mr. Washington, did you specifically request to be enrolled in the sex offender class?
No, ma'am.
And your crime involved a rape, didn't it? Aggravated rape?
Yes, ma'am.
Why didn't you ask to take the sex offender class?
Because once again, I asked the classification about it and they told me I wasn't charged with that, convicted of it, so I didn't need the class.
Right, but did you ask to be enrolled in it? You
No,
said you
ma'am.
okay. And you also took, I see where you completed a victim awareness class in, last year in 2023.
Yes, ma'am.
What did you learn from that?
Well, I learned not only that I had one victim, but I had multiple victims. And I didn't realize this. I thought I just had one, but I didn't realize that I affected her whole family and people that's for her friends and all the other people too. I didn't realize this at the time while I've been incarcerated, that I had so many other victims. So,
Right.
and
What impact do you believe your actions had on your victim?
well, too much. It devastated her. And each time I think about what I had done and how it affected her, you know, it takes my breath away that I'd done such a thing to this person.
All right, what kind of community service work do you do there at the prison?
Well, kind of help a lot of other people. I do hobby craft, so I help other people to learn how to do it in a proper way. And anytime it needs volunteers to go on cutting grass on Beeline or different other places, you know, I'm one of the first people to ready to go. So.
All right, I don't have any other questions. Any other questions?
I just have a statement from the 18th Judicial District Attorney's Office. They advised that they were opposed to the offender's request for commutation, and the 19th Judicial District Attorney's Office is opposed. And the 18th said they deferred prosecution of the aggravated rape. That's why you're not billed and charged with it, because it was a victim's consent, because it was too hard for the victim. I can tell you why, because it's too hard for the victim after we live the trauma and what happened to him, solely based upon the fact that this offender was convicted in our jurisdiction and sentenced to life. We strongly believe this offender has not served sufficient time to even be considered for commutation. We also believe he is a danger to public safety. So that was their statement.
Mr. Till?
Yeah, how old were you when you were incarcerated?
I was 23.
23, and the crime occurred at 23,
Yes, sir.
and you served how many years there?
October makes 38 years.
38 years. That's a long time. What's your educational background?
Well, I graduated from high school.
Very nice to you, and your mother said she reared you pretty good. You made some mistakes.
Yes, sir.
And you tried to take as many classes as you could that you were aware of to better yourself.
Yes, sir.
When was the last time you had a write-up?
2016.
2016. What was it for? You remember?
I'm trying to. Homosexual activity. That's the only thing I can think of. A 30W. I had a friend, I had a friend that's a homosexual, and somebody wrote a letter, and that's all I know about it. I never got a chance to read it. So
So have you learned a lot in those 38 years you've been there?
I learned plenty, sir, you know, and like I say, I'm ashamed of all the stuff that I had done to get myself here, but I have been trying to better myself and be a better person to not only people on the street, but the security here and other inmates. I think I'm a well respected person, and I have learned a lot, you know.
Good, good. I hope you continue trying to better yourself. I have no further.
Yeah, Warden Ambo, can you shed some light on that 2016 write-up?
Yes, ma'am. That's what I'm looking for now. Yeah, okay, they say on the above date and time, offender Jackie Washington is being placed in administrative segregation pending investigation for homosexual activity. And let me see, did I find the investigation? After concluding investigation, I, Lieutenant Chad Uber, have the following information. After speaking with offender Reinhardt in Washington, both offenders admit to me that they were both involved in a homosexual relationship with each other. Therefore, in my opinion, and due to the nature of this investigation, both offenders should be separated and listed as enemies.
Okay, and that was a 30W?
Yes, ma'am.
All right, thank you. All right, is the panel prepared to vote?
Oh, yeah, Tracy.
Oh, I'm sorry, Ms. Barbera, we'd like to hear from the DA's office.
Good morning. Thank you, Chairman Renata. Tracy Barbera for the 19th Judicial District Attorney's Office. I believe the record of this case speaks for itself. I also think that Jackie Washington speaks for himself in that he will not acknowledge that he is a sex offender. That is why he has not requested to take the sex offender treatment. While incarcerated, he, as we just learned, he still cannot control his sexual urges while incarcerated. And on September 1st of 2022, when he signed this request for clemency consideration, he signed a notarized document, and in his own handwriting, he wrote, "I asked her to have sex with me." You don't ask a woman to have sex with you at gunpoint. You force a woman to have sex with you at gunpoint. And I know acceptance of responsibility for what the individual has done plays a major role in your decision-making process. And I would submit to you this morning that we can set aside how long he's been in jail and the facts of what he did. The fact that he will not acknowledge that he raped her, I think is sufficient in and of itself to deny his request for clemency. And I would respectfully ask that you do so this morning. Thank you.
Yeah. All right, Mr. Freeman.
Okay, my vote is to deny. He needs sex offender treatment. You need to take it. You have a bad criminal history and a bad supervisory history. Virginia.
Mrs. Stapleton.
I agree with Mr. Freeman, and when I was reading the report, the thing that I noticed that he did ask for was that she kiss him. And so she gave him a peck on the cheek, and you told her that that was not enough. That's the only thing that I found that you asked your victim for. So my vote is not.
Mr. Tillis.
My vote is to grant.
To commute to what? To commute a sentence.
Commuted sentence, I'm sorry.
99.
99, yes. I apologize.
Mr. Prater.
Denied.
All right, Mr. Washington, the sex offender treatment is very important to me. That's why I asked you the questions I asked. I cannot make a favorable recommendation on your behalf without that in your back pocket. So my vote today also is to deny your application. And hopefully you'll ask these folks there at the penitentiary to get you enrolled in your class. I think you need to learn some things from it. So today you've received one favorable vote, but you've received 4 votes to deny your application for commutation of sentence. So today your application has been denied, sir. Good luck to you.
All right, thank you.
Well, we have the mic drop by my favorite ADA, Tracy. We got to see it there, and most of you know, I just totally adore her. She shows up And she shows up with the same compassion and passion and insight and knowledge about the case, about each case that she covers. And that's just more than any ADA that we see. And we once did a background story on her to understand who she is. And there's almost no information out there. She's someone who's basically has been in the field of prosecution for, I think, over 30 years. She lost her husband to in a terrible, way, uh, and it seems that she's thrown herself to being the voice for those who might not otherwise have it. And now this case, it is interesting, and we saw that Miss Stapleton, the victim advocate, who I think many of us are growing very fond of as well. She's a woman all the way on the left facing the screen. She's the one who replaced Mr. O'Shea's role. She brought up how, in his actual prosecution, how it doesn't mention the sexual assault, and it doesn't. I'll read to you the appeal, and all it discusses, all that he's convicted of, is aggravated kidnapping. Now, in this case, it's unlike the other sexual assault cases that we see where the DA is too weak and they're looking to do plea deals. And here they were getting life anyways. And they said, you know what? Why put this young woman on the stand if we don't have to? We're going to get him life anyways. And so it's not included in the appeal, and it's not included. And that's why he doesn't have in his classification as a requirement to have the to take the sex offender programs. So, to his credit, in his mind, he didn't think that he needed the programs, right? Like, he's been in prison a long time, 36, 38 years or something. But Miss Renatza and the other board members, they brought it up. They're like, well, I mean, just because it's not in classification doesn't mean you shouldn't request it. You are a sex offender, so you should know that you need to request it. And remember, this was all, he was not going to get parole. They wanted to say, are you going to recommend to the governor that I'll have a chance at parole? And he just, you can see how that ultimately went for him. Now he can come back and apply. I don't know if it's 2 years or 5 years. I forget the time length, or it's not maybe so much that I forget it, but maybe it's not so clear because they kind of changed the laws around that but let's just go over it. And before I do, let me just touch on Mr. Tillis. For those of you who are paying attention, watching enough hearings, you might realize that Mr. Tillis seems to be very lost in terms of he continuously, he's the one who was very excited to first see join the parole board because he was known as Angola's preacher. And I was excited for him to come. And I don't know if you remember when I first was reading about who the new appointees were of the governor, and I was excited to see him. I thought, wow, this could be interesting. But it's strange. It's actually, I think it's on the borderline of now it's embarrassing. He says, grant. And he does this with parole revocation hearings. He does it with parole hearings. He's doing it with commutation hearings. He's using the wrong verbiage. And look, that can happen at the beginning, but now he's how many 6 months into the job? If you know that you have a track record for saying the wrong things, I know I do. I'm learning disabled. I say the wrong things all the time. But if I'm on the platform, if I'm, just take your notebook, just put in the work, write down what I'm going to say. I'm going to say, I'm going to make a recommendation for the governor to commute his sentence to 99 years. I'll write that down. So when it's my turn, I'll be able to read it. And, he doesn't, it feels like it's so often where for revocation hearings, he'll say, I deny instead of, I revoke, or I grant instead of, I'm not going to revoke your parole. And it's the same thing, and it's driving it. It's weird. It's like, take your job seriously. And then also, when you're on the panel of 5 members and everyone without hesitation says we're going to deny, we're not going to recommend to the governor, I just did it, recommend to the governor to commute your sentence. If you're going to be opposing, then state why. And he alluded to why earlier in his conversations. He said, "Wow, you've been locked up a long time. You took a lot of programs," but he didn't take a lot of programs. He took, I think, 3 programs in nearly 40 years. Anyways, so here's the facts of the case. And again, remember, it's not going to touch on the sexual assault because they didn't convict him on that. So, and this incident occurred in the early mornings of October 16, 1986. The victim, a female student at Louisiana State University, LSU, had just left her friend's apartment where she had been studying and was returning to Herget Hall, her campus dormitory. After parking her car in the dormitory's extension parking lot, approximately a block and a half from Herget's Hall, the victim got out and started walking towards the dormitory. The victim had only walked a few steps when she saw the defendant coming towards her with a pistol in his hand. A pistol. The defendant forced the victim into his car, told her to lay her head down, and then told her that she would not get hurt if she did what he said. While holding the gun to the victim's leg, defendant drove to a location in West Baton Rouge Parish where he, it does mention it. I misread that. Where he sexually assaulted her. For some reason, I did not see that when I first read it. Defendant then stole approximately $40 from her. After learning that the victim had no more money in her possession, the defendant started to drive her back to campus. He stated he would drive her back to her dormitory, but since he did not have enough gas, he would have to leave her at a location a long way away from her dormitory. Fearing for her personal safety, if left at such a location, the victim convinced the defendant to stop at a service station so she could use her father's credit card for gas. They stopped at a service station, and the victim went up to the station's attendant's window to charge the gas. While the defendant pumped the gas, however, before she got out of the car, the defendant warned her that if she tries anything funny, she knew what would happen to her because he still had a gun in his pocket. The defendant then released the victim at her dormitory. And you could say, wow, I mean, he didn't kill her. We've seen so many of these stories where they do. Several days later, early in the morning of October 21st, 1986, the defendant stopped by LSU police officer Ricky Rubik in the parking lot of Miller Hall, a dormitory near Herget Hall. The victim was brought to the scene of the stop. So several days later in the early morning, which I suppose could be 1 in the morning or 5 in the morning, again, similar, the defendant was stopped by a police officer in the parking lot. So this was what Mr. Freeman was talking about. How, hey, weren't you stopped a couple days later at the same place? And so the police officer brought the victim to the scene, and she identified his car that she was forced into in the night of the kidnapping. So shortly after the stop, the LSU police officer Aubrey arrived at the location at the stop. After he advised the defendant of his Miranda rights, the defendant made a statement to him shortly thereafter. The defendant was taken to the LSU police department where he made a second statement to the police. The defendant was made to LSU police detective Warner and Baton Rouge Parish Deputy Sheriff Office. The defendant was again given his Miranda rights. A physical lineup conducted on the following day. The victim positively identified the defendant as the perpetrator of the instant offense, and at trial, the victim made a positive in-court identification of the defendant. So she did take the stand at trial, at least to make the identification. Then, part of his appeal was that he had no reason for him to be stopped. It was unconstitutional. And they're like, no, we had a bolo basically for your car. You did this just 2 days ago. The guy shows up back to the scene of the crime, if you can imagine, and they catch him. And I think Mr. Freeman pointed out, of course, he was going back there to do it again and would have done it again. You know, his mother gives a statement, and you got to feel bad for his mother. She's, you can argue, is a victim in this as well. But come on. I mean, the guy was out on, what was he out on probation, or he is, I think, out 2 or 3 months in total in like all those years. I mean, the guy was just a serial criminal. 2 adult felony probations, both revoked. He was only out for 3 months when he committed this crime. I have in the notes from Richard. So, oh right, then he has that DR for the sex offense thing, which must have been very embarrassing in front of his family if they did not know about this. We've seen a few times where it seemed apparent that it was the first time the family heard about it. Now, Ms. Renatza said that it was a 30W, which confused me a little bit because that's not. So you go to see 21 are the sex offenses, and 30 is not. It's general prohibited behavior. The following behaviors which may impair or threaten the security and stability of a unit. And that's what he got, which was W, which meant that any behavior not specifically enumerated herein that may impair or threaten the security, stability of the unit, or well-being of an employee, visitor, guest, offender, or their families may still be the subject of disciplinary report and all Schedule B penalties, except for forfeiture of good time. So, I don't know, it seems a little bit different than what we're used to seeing. But there you have it. And thank you, Richard, for calling out this hearing. You know, as I'm doing these hearings, many of you may know Richard is watching them, pointing them out, and saying, Mandy, you should cover this one. So, of course, thank you, sir, for that. And we'll, with that, I'll let you go.
And on September 1st of 2022, when he signed this request for clemency consideration, he signed a notarized document, and in his own handwriting, he wrote, I asked her to have sex with me. You don't ask a woman to have sex with you at gunpoint. You force a woman to have sex with you at gunpoint. You force a woman to have sex with you at gunpoint. And I know acceptance of responsibility for what the individual has done plays a major role in your decision-making process. And I would submit to you this morning that we can set aside how long he's been in jail and the facts of what he did. The fact that he will not acknowledge that he raped her, I think is sufficient in and of itself to deny his request for clemency. And I would respectfully ask that you do so this morning. Thank you.